My name is Danny Schaffzin, and I am excited and honored to be teaching what I think is your first official law school class. I know you've had a number of different sessions to this point, but I think this is your first of the classes that you're going to be taking throughout the semester, at least in the substantive areas of law. So that is a privilege of mine, and I look forward to it every semester. I cannot wait until we are actually together in the same physical space. I have faith that we will be, but for now, I want you to know how excited I am to be with you in this space. Here this morning, virtually, I am amazed, as I have been from the start of all of this, that we are able to be together in this way. And I am confident that though this arrangement is different, that everything is different these days, and I want to make sure that I know we're going to have a good experience together, but I want to make sure that you are no less inspired and motivated to do great this year. Virtual or not, everything is in place for you to succeed, and my faculty and staff colleagues are no less inspired and motivated to teach and support you. What is not different is that we look forward to supporting you and doing everything that we can to ensure your success this year. So I want you to know that. I want to start off by telling you that. And as I hope I conveyed in my e-courseware messaging, I'm not the best with all that, but as I hope I made clear, I am here to support you in any way that I can. My phone number, my cell phone and office numbers will be in every email that I send you. They're in those messages, and we all need that. So whatever I can do to help you this year, CivPro or not, I'm here to do that. And I'm excited to be with you. So let us get started. One thing I'm going to ask you to do is practice in the chat. Just type the word here, okay? For now, that's how we're going to do attendance, and we're going to see how that goes. There are other ways that Zoom accounts for you being here. I'm also going to ask that I will do some calling on folks, okay? Do not be intimidated. We're here. It might be you that gets called on first. I'm going to work with you to get through the experience and get through it well, okay? But if you have questions along the way, put question in the chat box, and I'm going to try to make sure that I can see that. If I don't, wave your hands and just know that it's possible I may not see you, but I will do the best that I can, and we're going to figure this out. Okay, I'm going to share my screen. And let's do this. Y'all ready? Get some head nods? Good. All right. So what is civil procedure? Civil procedure is, very generally, the rules by which courts conduct civil cases. Okay, civil cases concern the judicial resolution of claims by one individual or entity or class of individuals that are brought against other individuals or classes of individuals or entities. Civil trials are different from criminal trials. Criminal trials or criminal cases involve the government prosecuting individuals or entities for violations of criminal law. And this course is focused exclusively on the elements of civil cases, of civil lawsuits that are generally between private parties or between two parties. Okay, the government can be a party in a civil lawsuit, but the government is not a party in the sense of prosecuting criminal conduct. Okay, that's criminal lawsuits. So take, for example, a dispute involving a written contract with you that you entered with Widgets R Us. Widgets you'll hear a lot about, I'm sure, in law school. Widgets R Us, you paid them $100,000 to buy 1,000 widgets, and you paid the $100,000. You have the proof of payment. You paid a check. It was deposited. But Widgets R Us never delivered the 1,000 widgets within the 30 days that they were supposed to under the written contract. You have never received the widgets you ordered. They've never been delivered to you. You might have the most compelling open and shut case in the world. You have a written contract, you have proof of deposit of the $100,000, right? You might be the most sympathetic plaintiff in the world. You've lost everything because you haven't gotten these widgets. None of it is going to matter if you don't know things like which court to file your lawsuit in, who else might need to be a part of that lawsuit, either on your side or on the side of widgets are us, right? If there are other entities or individuals you need to sue to make sure you can recover as you believe you're entitled to, and then what to do during the lawsuit once it's filed and moving towards a trial. All of that is civil procedure. And we are going to study everything from selecting a proper court and proper parties to commencing a lawsuit, how to start a lawsuit and how to move it through discovery, figuring out what the applicable law is, how to formally discover, as I said, or gather evidence and information that you might eventually use at trial or in other ways before trial, right? And then how to engage in motion practice from the start of a case all the way up through and including during and after trial. There are motions. All of it is civil procedure, okay? We're going to start from the beginning on Monday, but today we're going to spend some time on subject matter jurisdiction, okay? So what is subject matter jurisdiction? For a court to properly preside over a lawsuit, once it's filed, that court has to have what's called jurisdiction over the subject matter of that lawsuit. In other words, the court has to have the authority to adjudicate the type of controversy, right? In the example I just gave you, a breach of contract case, a court, in order to keep that case before it and actually adjudicate it, needs to have subject matter jurisdiction over contract cases. During next Monday's class, we're going to talk about the two principal systems of courts in our country, the federal court system and the system of courts in each state, the state courts. The federal courts and the state courts are structured very similarly. You have sort of at the bottom rung looking up, you have trial courts where cases are filed and they are adjudicated through motion practice, right? Factual and legal disputes. You either have a jury or judge sitting as fact finder and the judge as the decider of the law, right? And the case is one way or the other adjudicated, right? Each system has trial courts, federal and state. They also each have appellate courts where the decisions of the trial courts can be reviewed on appeal, right? Each state has its own courts of appeals and then Supreme Courts. And likewise, the federal court system has trial level courts, the U.S. district courts, then the U.S. courts of appeals are an intermediate level of appeal, and then the U.S. Supreme Court you all know about. While they are structured similarly in terms of the types of cases that federal courts can hear, the federal and state courts can hear what we refer to as subject matter jurisdiction. The federal and the state courts are very different. One of the things you need to consider in that widgets case you are getting ready to file, right, for breach of contract, is whether you can file your lawsuit in state court, in federal court, or in either state court or federal court. That decision is often going to turn on an understanding of each court's subject matter jurisdiction. What kind of case can either state court or the federal court hear the breach of contract case you want to bring? That is subject matter jurisdiction. Now, this is a court, right? These are the things we're going to study. Okay, and I'm going to post all my slides for you to see on Twin, so don't worry. Right, I just mentioned this. This is a course in federal civil procedure. Most law schools teach federal civil procedure. Okay, each state, including Tennessee, has its own set of rules of civil procedure. Often they are very similar to the federal rules, but we're going to focus on federal civil procedure. As the course name suggests, we're a federal civil procedure course. We're going to spend nearly all of our time together over the next 9 months. You get me for 9 months or so, focusing on the practice and procedure of the federal courts. But it's important that you understand that the allocation of power between the federal courts and the state courts weighs heavily in favor of the state courts. And here's what I mean. State courts are courts of general jurisdiction, meaning that their subject matter jurisdiction is very broad. State courts can hear most types of cases: contract lawsuits, property-related lawsuits. Often, state court systems have specialty courts like an environmental court or probate court or family court, where those types of disputes are litigated, right, and resolved. By contrast, the framers of the Constitution did not believe that the federal trial courts should handle the lion's share of litigation in this country. The notion of federalism you will hear about throughout law school, right? In general, a deference of by the federal government to the states, right? And the powers of state government. Well, that carried over. The framers didn't think federal courts should be the ones resolving most of the disputes in this country. They felt the state courts should. They felt that the federal government was supposed to be a government of limited powers, and likewise, its court system should be limited in its subject matter jurisdiction. So whereas there is a presumption that state courts, in one way or the other, can hear almost any type of case, the opposite is true of federal courts. And we will study subject matter jurisdiction, right? I want you to understand that subject matter jurisdiction of the federal courts is exceptional. It's narrowly tailored. It's limited, okay? Subject matter jurisdiction, another way to think about it is, can a case go forward in one court or the other? And we're going to spend a lot of time thinking about whether a case can go forward in federal court or not, okay? Even when a federal court might actually have subject matter jurisdiction over a certain case, it is often the case that the same lawsuit can also be filed in state court. It's not going to be filed in both, right? But that's how broad the state court jurisdiction usually is, okay? And that is called concurrent jurisdiction, when a case could be filed in either a federal court or a state court in terms of subject matter jurisdiction, the ability of a court to hear the dispute at issue in the lawsuit. So to what sources do we look to determine the subject matter jurisdiction of the federal courts? Okay, who can tell me? Somebody put in the chat, hand or answer. What are the principal sources of the law governing subject matter jurisdiction of the federal courts? Mr. Norwood, make sure you're off mute. Tell us.
Yes, sir. So the U.S. Constitution, Article 3, subsection 1 and 2.
Constitution. We'll get to the specifics, but that's right. Okay. What else?
And then another one is 28 U.S. Constitution 1332.
Okay, those are both constitutional. Okay, I'm sorry, 28 U.S. Code. So who is that part of the Constitution?
No.
No, it's not U.S. Code. Who legislates? Who makes law in the federal government? Congress does, right? So we have the Constitution, and then we have statutory, okay, authority, right? So you are absolutely right, and those are the principal sources. Specifically, we'll get to them. Mr. Wright, I appreciate your eagerness. I'm going to ask folks not to do that, right? Put answers in chat, okay? Want to make sure that we at least have an opportunity. I'll prompt you if I want you to do that, okay? And thank you, Ms. Davis. We will come back to you. Okay. All right. So we have constitutional authority to look to, and then statutory authority legislated by Congress that tells us what the subject matter jurisdiction of the federal courts is, okay? Let's talk about the Constitution. All right, Mr. Norwood, can I stick with you for a minute? Okay, Mr. Norwood, tell us, you were getting to it. What part of the Constitution tells us about the subject matter jurisdiction of the federal courts?
Article 3, subsection 1 and 2.
Okay, Article 3, subsection 1 or 2. Tell us, what does it say?
So it says that the Supreme Court has the authority of all the lower courts. So with the decisions it makes has precedent over everybody else. So it has a supreme authority. It also says that the judicial power extends to all the courts underneath it. So
Okay.
they can make decisions that don't supersede the Supreme Court. It's saying that foreign bodies are automatically sent to the Supreme Court level. So state bodies cannot intercede on foreign body matters.
Okay, but
And
tell me,
then,
Mr. Norwood, what kinds of cases? Look at Article 2. Tell me, just straightforwardly, what does it say about the kinds of cases federal courts can hear? Don't worry about Supreme Court or other courts. What does it say?
it's talking about stuff that has to do with in between states and stuff
Okay,
with foreign
good.
bodies, like foreign countries.
Okay, so where are we? Where are we in section 2?
I jotted down some quick notes, but I can pull up.
Why don't you look at it? Everybody look at section 2, Article 3, section 2 of the Constitution, page 10 of our supplement.
Oh, so,
One thing I want you to do there is no replacing the actual source itself. When we're talking about rules and statutes, let's look at them. Let's look at them together. Okay? So Article 3, Section 2 starts off. It says the judicial power shall extend to all cases. It's talking about the federal judicial power, right? All cases in law and equity. And then it starts a list, right? Starts a list. Here's the list. Okay, there are 9 bases, right? 9 areas articulated by Article 3, Section 2, where the federal court has over which the federal court has limited subject matter jurisdiction, right? To hear these kinds of cases arising under the laws of the United States, right? Whether it's constitutional law, statutory law, right? Okay. Cases affecting ambassadors, cases over admiralty, maritime jurisdiction, where the U.S. is a party to the lawsuit, either as a plaintiff or as a defendant. When you have a controversy between 2 different states, where one state is a party to the lawsuit, okay? Then you have cases involving citizens of different states. We're going to put that to the side because we're going to focus on that in a little bit. Cases involving land grants, and then cases involving states or citizens and foreign states, citizens or subjects. Let's pick a couple of these. I want to know why. Why do you think the Constitution, the framers, would give federal courts the ability to hear these type of cases? Let's pick one. Cases affecting ambassadors. Why? Ms. Davis, do you have a question or an answer?
I have neither now.
Okay, we'll get there in a minute. Mr. Rosencrantz.
Because those are affecting people that are supposed to represent their countries. So
Okay.
it's sure that the federal court is the one handling that.
Okay, good answer, right? Ambassadors are involved in matters of international relations, right? Generally, matters of international relations are delegated to the federal sphere, right? To the federal government. Good, Mr. Rosencrantz. How about cases where the U.S. is a party? Why would federal courts have the ability to hear those cases? Mr. Baskin. And if I'm mispronounce your name, correct me.
Baskind.
Baskind, okay.
No relation to Carol from Tiger King.
Got you. An
But
important clarification in the here and
yes,
now.
but the federal government would it'd be tried in federal court if the United States is a party because it's not a state issue.
Not a state issue. What do you think, Mr. Baskind, that the framers thought in terms of the idea that disputes involving the U.S. as a party being adjudicated by state courts? What was the concern?
That I would venture a guess to say that if it was in a state court, whatever state it was being tried in would try to make it more, whatever the outcome, more advantageous to themselves. It'd be a more statewide issue if the United States is a party.
Okay, we don't want states deciding matters involving the United States, right? The federal government, okay? Mr. Gould, I don't want to skip you because I saw you volunteered. Pick one of these and tell us why the framers would include it in Article 3, Section 2. Mr. Gould, are you here?
Yes, sir.
Go ahead.
I'll pick
Maritime. Good. Go ahead.
with the seas and kind of piggybacking on different countries. The seas span all across the globe, so they kind of encompass all land and sea. So you'd want a overarching jurisdiction on that one of the federal
Good.
government.
Cases within admiralty jurisdiction may arise from accidents on waters of the United States, not a specific state necessarily, right?
Mhm.
They involve some aspect of maritime commerce, right? Like when two ships collide or when somebody gets hurt, right, on a vessel that's in service. Do we want a specific state adjudicating that dispute, or the federal government, where those waters don't necessarily belong to a specific state, right? Good. You get the idea. There, for all of these, right? And there's one other that I want to cover. Mr. Goff.
Yes.
Mr. Goff, I'm disappointed you're not wearing, were you wearing a Manchester United jersey the other day when I saw you?
Yes, I was.
That was money. I like it. I back it. Not I don't like United, but I like the jersey. Anyway, Mr. Goff, tell me about why would the federal courts have jurisdiction over cases that arise under the laws of the United States? Why would they and not state courts have that subject matter jurisdiction?
Well, I would think it to be because they have a more overarching view of what they want to get accomplished, like that benefits the whole country instead of just piecemeal this state versus, another state.
Good. Okay. You have, let's take a federal age discrimination lawsuit, right? Federal statute says that an entity cannot discriminate on the basis of age, and it creates a cause of action. The ability of a party, an individual who is allegedly aggrieved, right, where there's a violation, alleged violation of that statute, to file a lawsuit. Congress created that law, created that right to sue. So it makes sense that federal courts, right, would be able to adjudicate that dispute involving federal law. Okay? Good. So you get the point. Here, every type of case identified here, there's some reason why, and we'll talk about diversity of citizenship in a moment, some reason why the framers wanted federal courts to have the ability to adjudicate disputes involving these issues, okay? We'll get back to that with diversity. But the Constitution tells us about the subject matter jurisdiction of the federal courts, right? It's right here. And we heard that Article 3, Section 2, we see it. It starts right off and tells us the kinds of cases, right, that federal courts can hear in terms of subject matter jurisdiction. So why do we need federal statutes then? Okay, we heard a moment ago that federal subject matter jurisdiction, and we correctly heard, also turns on federal statute. Why? Why, if the Constitution, right, the end all be all of law in this country? Okay, Mr. Goff?
Because I would say that the Constitution, it's the baseline, but obviously it was written hundreds of years ago. So with current federal statutes and legislation, that's with the time. So they can adapt and change to what this country actually needs now.
Okay, that makes sense. It makes sense sort of from a policy standpoint, but there's another source, right? Mr. Cook, why do we also need federal statutes to further determine exactly what kinds of cases federal courts can hear?
So they had it laid out to where Congress could come and make a statute that doesn't fully encompass the entire scope of what the case kind of sets it out to be. So kind of like in the diversity thing where they're the $75,000 minimum.
Yep.
So it kind of allows Congress to kind of limit exactly what federal court has to hear.
I'm hearing 90% correct, Mr. Cook. What tells us that Congress can do that?
The Constitution.
Yes, where?
It's in section 2.
Okay, tell us. What language are you looking at? You're telling us that the power of subject and the power and really the subject matter jurisdiction of the federal courts is not self-executing, right? The Constitution does what? What does it say in terms of, first of all, Mr. Cook, what does it say in terms of the courts? What does it establish? Which courts?
I'm looking for the exact wording right now, but
Okay.
I know it establishes like the Supreme Court.
Yes. What else does it say? Look at Article 1. The judicial power of the United States shall be vested in one Supreme Court. And then what does it say?
I'm sorry, that's going very slow right now.
Okay.
It's one Supreme Court, and it oversees.
Mr. Walker. I'll come back to you, Mr. Cook. Mr. Walker. Are you here? Romeo.
I'm sorry, I was on mute. Yes, sir. I'm
It's
here.
okay. What's it say?
Article
1. Article 3, Section 1.
Article 3, Section 1. I guess it says the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The
And in
judges,
such inferior courts as the Congress may from time to time ordain and establish.
yeah, so that means
Yes, go ahead.
yeah, so that means pretty much that the legislature pretty much lays down the law and everything, but it's up to the judges of the Supreme Court to interpret and find out the meaning of this. Of these,
Well, not exactly. What does this say? Congress can do what? Or ordain and establish what?
ordain and establish the judges, both of the Supreme and inferior court shall hold their offices during good behavior.
So no, Article 3, Section 1 says that first sentence, just that first sentence says that it's Congress that can create from time to time, ordain and establish inferior courts in the federal court system, right?
Yes, sir.
Okay, so the Supreme Court is there, but the Constitution seems to leave it to Congress to create lower courts, right?
Yes, sir.
Okay, so that's one way that the Constitution limits the power of federal courts, right? It says that Congress has to actually create them, but we're talking about subject matter jurisdiction, right? Let's go back to Article 3, Section 2. Mr. Cook, I'm gonna come back to you. Did you find what we were talking about earlier? Why do we have in the Constitution, in Article 3, Section 2, this list that tells us, purportedly, the subject matter jurisdiction, the categories of cases that federal courts can hear, okay? Why do we need also statutory authority? Come off again.
So, like, they're laying out these different things in the Constitution, but they're still very broad. I feel like statutory regulation kind of reins it in to where it's giving a more specific look at what cases that they have to try. So not only they kind of have some guidance, but also they're not just getting overwhelmed with cases.
Okay, that again makes sense from sort of in the abstract, right? But point to specific language for me. The Constitution here tells us, right? Ms. Rice, you want to take a shot?
I'm not seeing the specific language you're referring to, but my thought process was, so the federal jurisdiction isn't overwhelmed. They can pick and choose what needs to be applied in certain cases.
Okay, again, that makes sense, sort of along the lines of what Mr. Cook just sort of offered, right? But there's something more specific. There's language here. Who can point it out? Mr. Norwood?
Yes, sir. So in Section 2, the second paragraph, the last sentence is saying what jurisdiction the Supreme Court has.
Read it
Both
to
as-
us.
It says, in all other cases before mentioned, the Supreme Court shall have appellate just jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make.
So
So-
like Article 3, Section 1, It gives the power to Congress to do what? What do you think, Mr. Norwood?
To make the exceptions and regulations so that they don't overburden the Supreme Court.
Okay. All right. So Ms. Rice, Ms. Cook, you're in the right place. Okay. Ms. Rice, Mr. Cook. Okay. But that's the language, right? Article 3, Section 2, after listing these 9 bases, right? These 9 bases of federal subject matter jurisdiction goes further to say, in all cases affecting ambassadors, other public ministers and consuls, and in those in which a state shall be a party, okay? And those, the Supreme Court shall have original jurisdiction. So original jurisdiction means if there's a lawsuit involving them, they are the trial court, the Supreme Court, right? Not an appellate court. They have original jurisdiction in those limited kinds of cases, right? But, okay, in all other cases before mentioned, referring to the other cases in the list of 9, the Supreme Court shall have appellate jurisdiction like we're used to it having. It can hear appeals, both as to law. In fact, with such exceptions and other such regulations as the Congress shall make. So, the Constitution gives Congress a lot of freedom in allocating to the federal courts or withholding from the courts the subject matter jurisdiction that Article 3, Section 2 contemplates. Congress has to give lower courts, okay? Courts other than the Supreme Court in the federal system, Congress has to give those lower courts subject matter jurisdiction, even when the Constitution itself explicitly lays out the 9 bases of subject matter jurisdiction. There still needs to be a statute legislated by Congress authorizing the federal courts, the lower courts, the U.S. district courts, to hear those kinds of cases. Remember, right, the federal courts, the framers designed this system so that the federal courts would be courts of limited jurisdiction. And Congress acts to regulate those limitations. Here's another way of looking at it, okay? The Constitution is the yellow. Can y'all see the colors on this screen? Okay? The Constitution gives us the 9 bases. They are in the bigger of the circles. Congress has to legislate to specify what the jurisdiction, subject matter jurisdiction of the lower courts is, right? And that's the smaller purple circle, okay? In learning about federal subject matter jurisdiction, okay? Right? In learning about federal subject matter jurisdiction, we're going to focus on 2 types of cases that can be heard in federal court, right? Where most of the jurisprudence lies in federal subject matter jurisdiction. Most of the cases, diversity of citizenship jurisdiction, right? Disputes between 2 citizens of different states, and federal question jurisdiction. And Mr. Goff told us disputes arising under the laws of the US, the United States. These are the leading forms of subject matter jurisdiction that are invoked when private parties litigate in federal court. In other words, these are the 2 bases, right, under which when private parties litigate, when a lawsuit is filed in federal court, right, that's how, under one of these 2 is usually the way that the case stays in federal court, right? It's under one of these 2 categories that the court is able to assert its subject matter jurisdiction over the case. We can hear this kind of dispute, okay? What is the public policy rationale behind diversity jurisdiction? And let me just say something about public policy. You'll hear this term bandied about, you may have already. It always intimidated me when I was a law student. I don't want it to intimidate you. By public policy rationale, I mean the principles on which the laws of our country are based. It's important to understand the difference between a policy and a law. A policy outlines what the government hopes to achieve, okay, and the methods and principles that it is going to use to achieve those policies, okay? It states that the goals of the government, taking into consideration what the goals are, taking into the consideration that will benefit the public most, okay? Laws set out the actual standards, the procedures and the principles that have to be followed to give effect to that underlying public policy. Okay? So thinking in terms of public policy, Ms. Chapman, I want to call on you, just give you an opportunity because I know you had volunteered to answer. So the question is, why should federal courts, from a public policy standpoint, have the ability to resolve disputes between citizens of different states? Okay? All these categories, there's some reason why the framers would give the federal court the ability to be the adjudicator of the dispute. So all these, it's clear when the U.S. is a party or cases involving admiralty or maritime jurisdiction. Why disputes involving citizens of different states?
Possibly that different states have different like superior or supreme courts, and so
Okay.
there are different policies that have been drafted.
Okay.
So there's like discrepancies between the states of what the policies mention.
Okay. So for a consistency purpose, right? Mr. Martin?
For bias,
Bias, tell us more.
if one of the like, it's kind of like a home and away game.
Yeah, I like it.
Like if one of the courts, if one of the parties in the case, if the court from their hometown tries it, and he's like a prominent member of the community, then it might lean more towards him. But yeah, I think it's mainly for the bias factor.
Here, the federal court, the Constitution, the drafters, the framers, they wanted to ensure a neutral forum, right, for cases involving a risk of local bias. When you have a case like that is brought in one state court or the other, one litigant, one party or the other might end up litigating in the local courts of the other party's state, okay, and may not get the same sort of fair treatment that somebody in the home state court would get. Does that make sense? Right? So the framers saw this. They want to give power to the states, but this was an appropriate limitation. This is the kind of situation where citizens from two different states may have a matter of state law to litigate, right? A contract dispute. But it would be unfair if me in Tennessee, I file a lawsuit in Tennessee courts against somebody in Kentucky who I'm saying didn't pay. Widgets are us, right? Why should Widgets are us have to litigate in my home state when alternatively they can litigate the case in a federal court that might be said to be more neutral, less biased when it comes to both parties, okay? So that's the public policy rationale. The framers were concerned at the time that creditors out of state, right, wouldn't be protected trying to collect debts from local citizens, right? The state courts might be more protective of creditors that actually had a right to be collecting. We also have a situation where in most states you have elected judges. The framers likely anticipated a more even-handed treatment of out-of-state litigants by federal judges who are appointed for life. And in the end, today you have about a third of the cases filed in federal court are based on diversity jurisdiction. In other words, they might involve matters of state law, not federal law. The cases don't arise under the laws of the United States, but they're in court because they involve citizens of different states. Even though the Constitution says that federal courts can hear disputes among citizens of different states, it also says that Congress actually has to give that subject matter jurisdiction to the federal courts, right? Remember? Okay, Congress actually has to create law, legislate that subject matter jurisdiction, even if it's in the Constitution. So what is the statute providing lower federal courts subject matter jurisdiction over cases involving diversity of citizenship? Mr. Davis, you want to take a shot at this? You volunteered.
Sure. I'm not sure, but is it the USC 28?
What's 28 USC? What section?
It is section. I just have 28 USC 1332.
You have it right. Okay, 28 USC 1332. Do you have it in front of you?
Nope, I just have it written down.
Okay, well, pull it up in front of you. Y'all listen, one good suggestion I have for you when you are coming to class, if you're assigned a case, you're assigned cases, statutes, whatever, have them with you. Have them within arm's reach. If they're on your screen, have them ready to click on, okay? Because your professors are going to want to refer to them, and you're going to want to be able to read them, to look at them, right? To answer questions based on them. Mr. Gould, you've been actively volunteering?
Yes, sir. Did you just
Gould.
want me to read it?
Well, no, I want you to tell us, 1332, that's the statute. What does it do as far as diversity of citizenship relative to what's in the Constitution? The Constitution says that federal courts will have jurisdiction over cases involving citizens of different states. Does 1332 just mirror that language?
More or less, but it kind of brings, to lighten the load of the federal courts, brings the federal district courts into play, but they have to meet certain requirements, and that's where it's the specific sum of no less than $75,000 that the plaintiff is seeking, I believe. And then it also goes into, it must be, I guess, upon when the action is brought to the court, the two citizens must be have different domiciles.
Okay.
And that's kind of what we read further into.
Okay, we'll talk about the case. But as far as what the statute says,
Okay.
You're right, it's different. Is there any mention of any sort of amount in controversy, $75,000 or any other amount in the Constitution?
No, sir.
No, right? So we go back to this language of Article 3, Section 2, where it says, in all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and to fact, with such exceptions and under such regulations as the Congress shall make. So it looks like one of the exceptions or regulations they made in terms of diversity of citizenship jurisdiction has to do with an amount in controversy, right? The Constitution says that the case must be between citizens of different states. In the statute, 28 USC 1332, Mr. Davis told us, right? Congress conferred only some of that jurisdiction available under the Constitution, providing diversity jurisdiction when the case is between citizens of different states and the matter in controversy exceeds the sum or value of $75,000. And by the way, that amount in controversy has changed over time, right? It used to be $50,000. It was a smaller amount before that. Congress has continued to legislate that with inflation, right? Okay. So we know that federal diversity of citizenship jurisdiction as a specific type of federal subject matter jurisdiction arises from both the U.S. Constitution, Article 3, Section 2, and from statute 28 U.S.C. 1332, legislated by the United States Congress. So why the heck, Mr. Gould, are we reading a case about diversity jurisdiction? We already have constitutional provision and we have a statute that tells us clearly federal courts have subject matter jurisdiction over cases involving citizens of different states. Why are we reading a lawsuit about this, a case? Courts don't make law, right? Courts interpret law. So why are we reading this?
I guess because it gets kind of murky when you're deciding if someone is an actual home resident or a state is their actual domicile, I believe is the word they were saying. And that's why cases arise, I guess, is because you have to define what is their home base.
Good. Okay. You're pointing out an area that is subject to interpretation, where that interpretation is not given clarity, right, by either the Constitution or the statute. Courts interpret law, okay? And in doing so, they create a different kind of body of law, common law, right? Even with the constitutional provisions and the more specific provisions of 28 USC 1332, it is accepted principle, right? And it makes sense that the constitutions of the federal government and states and statutes, they can't anticipate all of the issues that are going to come up in the actual practical administration of those constitutions and statutes, right? There still remains details about diversity of citizenship jurisdiction and all of the other bases of federal subject matter jurisdiction that need to be fleshed out. And that's where the federal courts come into play. Courts, as I said, are called on to interpret statutes and constitutional provisions to fill in the gaps and to flesh out their meanings. And that's where the excitement is. That's why you are coming to law school, right? Some of you may engage in creation of law, right? Eventually legislating, serving in that way, and using your legal training. Some of you are going to be, probably more of you, are actually going to be involved in disputes involving the interpretation of legislated law. Okay, lawyers need to be creative and careful in advocating for the meanings that they believe will best serve their clients. Okay, judges need to weigh those arguments and determine what the meaning to assign to govern the issues in the cases at hand. So yes, both Article 3, Section 2 of the Constitution and 28 U.S.C. 1332 establish this grand overarching principle that a federal court may hear cases involving diversity of citizenship when cases involve citizens of different states. But this idea, as Mr. Gould tells us, this meaning of what it means to be a citizen of a state, the Constitution doesn't tell us that. And the statute, 1332, 28 U.S.C. 1332 doesn't tell us that, okay? So the courts have needed to bring that clarity over time to establish the rules of interpretation in individual diversity cases, okay? And Gordon versus Steele is one of those cases, okay? It helps us to answer what legal standard a court should apply to ascertain a person's citizenship for purposes of diversity, right? To determine whether a court actually can keep a case, a federal court can keep a case on the basis of diversity of citizenship jurisdiction. All right. Austin Henderson. Austin, are you out there?
Yes, sir.
Okay, Miss Davis, Austin, hold on one second. Miss Davis, what's your question?
I was just wanting to clarify something. So the 28 USC section 1332, that is one of the statutory grant of subject matter jurisdiction. That's what that falls under.
Yep.
Okay, I was just trying to draw the correlation. I wanted to clarify.
No, that gives effect, that is Congress giving effect to that last sentence of paragraph 2 of Article 3, Section 2. You got it? Okay? Right. When you see U.S. Code, Congress creates U.S. Code. They legislate, right? When they pass statutes. That's what this is. Good. Okay. Mr. Henderson.
Yes, sir.
Good to see you.
Good to see you as well.
Forevermore, Mr. Henderson, you are going to live in the lore of Section 12, class of 2023. Okay? I'm going to make sure it's positive lore. So stick with me for a little bit, okay?
Gotcha.
All right. Tell us, give us the backstory of the Gordon versus Steele case. What happened to Susan Gordon? What brought this case to court?
So Susan Gordon is the plaintiff in this case, and she suffered a wrist injury, and she claims that she was given a wrongful diagnosis by the defendants about the severity of her injury.
Okay.
And then she claimed that as a result of this misdiagnosis, her wrist and hand ended up partially disabled. And during the time of the misdiagnosis, she was living in Erie, Pennsylvania, but enrolled in school in Idaho about 5 months later, where she lived, and that's where she lived when the suit was brought to the court.
Where was the suit filed? What court? Do you pick that up?
It was filed in a district court in Pennsylvania.
Okay, so federal courts, right? United States District Court for the Western District of Pennsylvania. You got it. Federal court, federal trial court, all right, in Pennsylvania. But she lives in Idaho. Where are the defendants? Where are they located?
They are located in Erie, Pennsylvania.
Okay, in Pennsylvania, right? So no dispute about where they're citizens. They were in Pennsylvania when they provided the treatment to Miss Gordon, and they remain in Pennsylvania, all right? So yes, we have a medical malpractice case. She files in federal court. Medical malpractice cases, tort cases, they're really state law cases.
Right.
right? Filed in state law, but she files in federal court. What is the basis, right? She asserts in filing in the United States District Court, in federal court, she is asserting that the federal court has subject matter jurisdiction, has the ability to hear that type of case. A medical malpractice case usually is filed in state court. What is the basis asserted for the federal court subject matter jurisdiction?
Was that through diversity jurisdiction?
Good. Specifically what? What do we need to have if there's diversity here?
We need to have citizens of the separate parties living in different states.
Not living, right? They need to be citizens of different states, right?
Well, yes, sir.
Okay,
Citizens
and so
of different states.
what are they claiming then? Do you just tell us who's on either side? You have, who's the plaintiff?
We have Miss Gordon as the plaintiff.
She's a citizen of what, if you're to believe that there's diversity?
She's a citizen of Idaho.
Okay, she's clearly claiming that, right?
Yes.
Okay, and because where are the defendants?
They are in Pennsylvania.
Okay, so the claim is that they are citizens of Pennsylvania, that you have diversity. That's what she, in filing in the U.S. District Court for the Western District of Pennsylvania, that's what she's claiming, okay? Tell us some of the key dates, Mr. Henderson, because there are a series of dates, and I'm a big believer in timelines, all right? What are some of the dates at issue here?
So it says the plaintiff, Susan Gordon, is one of those who benefited by the provisions of the aforementioned Emancipation Acts of June 16, 1972, since she was born on November 20th, 1953, and was 18.
Why does the court tell us that? Why do they give us her date of birth? Why do you think? You're getting to it. Why?
Because it lets us know that she was 18 years of age when the cause of action was brought, and 19 at the time. At 19 at the time, the action was brought on April 10th, 1973.
Okay. She's the court's explaining, right? Most states have lowered the age of majority to 18. Right. So the traditional rule that college students, right, those under 21 are minors, no longer applies. So it's important, right? Because if she's a minor, who does she live with?
She lives with her parents.
Who are where?
In Pennsylvania.
Okay, and that destroys what?
Diversity jurisdiction.
Good, Mr. Henderson. Excellent. Okay. What's the next date? Let's see. February 25th, right? Date of injury. Right. All right. What's the next date?
The next date is August 9th.
Good. What's that?
And that is when she enrolled in Ricks College in Idaho.
Okay. Now known as, anybody know what the school is now called? I believe it's BYU Idaho. And the reason I know that is because 2 years ago in my civil procedure class, we had like 3 students who went to BYU Idaho. And some of them, I think some of them are going to be third years. I might bring them in for a guest appearance. Okay.
That makes sense. That makes sense based on the fact that it was mentioned she's a Mormon. So.
Okay, that's right. And she goes to Ricks College. And what does she do? What does it tell us about her time at Ricks College? She goes there to be at school. And what does she do?
She rents an apartment that she has that she's still living in.
Good.
At the time of the case.
Good, which she has retained ever since, the court tells us. Okay, the court also tells us that before August 9th, 1972, what is clear before that date as far as her citizenship?
Before August 9th, that she lived in Erie, that she lived in Pennsylvania.
She was a citizen of
Pennsylvania.
Excellent. Okay, right? She was a citizen of Erie, Pennsylvania, and if that continued to be her address, then the suit has to fail. The court says that, right? If we're looking at it before August 9th, 1972, right? What's the next date? The court tells us.
After August 9th, January 21st, 1974.
Okay, there's one date in between, right? When did she file the lawsuit?
She filed the suit.
It's on the screen.
Oh, she filed the suit April 10th.
Good. April 10 of?
1973.
Good. And then what happens in January 1974?
The defendant filed a motion to dismiss the case based off the lack of federal jurisdiction.
Okay. So we have this case filed in 1973 in April. The defendants move in 1974 right, early, but several months after the case is filed, the physician defendants move to dismiss. This case is an opinion from the trial court. It's not on appeal, right? Normally, we're going to be reading appellate cases where there's been an underlying ruling on the law, right, by the trial court, and the appellate court, right, is making a determination about whether it was correct, a correct application or not. Okay, this is a trial level decision. This is the court deciding whether or not it can keep the case based on subject matter jurisdiction, specifically diversity of citizenship. Okay, so the defendants move to dismiss. They file a motion to dismiss. Procedurally, that's how you speak to the court, through motions. And they file a motion, they move the court to dismiss. The doctors say, this case needs to go away, court. They don't speak at all to the validity of the lawsuit, the substance. They say this case needs to go away from this court because this court does not have subject matter jurisdiction. It doesn't have the ability to hear this kind of case because it doesn't fall under any of the 9 categories, including diversity of citizenship jurisdiction, right? That's what they need to show here. Or do they need to show it? We'll get to that in a second. The issue is whether the plaintiff was a citizen in the state where she attended college or in her home state, right? In Pennsylvania. Okay, so of the dates provided, Mr. Henderson, which did the court deem to be sort of most important? Which did it deem to be most important, in your opinion?
My opinion, I believe it was the date of emancipation.
Well, they said that was important because that meant she could file the lawsuit, right? If that's the most important date, then is she a citizen of Idaho or a citizen of Pennsylvania?
I would say citizen of Idaho.
No. If she's emancipated.
Yes.
Yes, I understand what you're saying. Okay. But what date, if we're looking to determine the issue of citizenship, what date does the court say is most important? When do we need to look, right? What date is most relevant according to the court? Citizenship as of what date?
Oh, the date when she filed suit.
Good. Okay. April 10, 1973. The court says, right, as far as the timing of a citizenship determination for diversity cases, court looks to the party's citizenship at the time the lawsuit is filed. Good. Okay. Why not use the date of the trial? Mr. Henderson, what do you think?
Because it could change in that time period.
Okay. Court's not going to know, well, it could change. And to have the court adjudicate a whole case, to let all the money and time be spent only to make a decision by the time the case is over, that sort of doesn't make sense, right? Okay. As far as the date of the claim, that the claim arose, why do you think we don't look to that date, right? She was injured back in what, 1972?
Right.
We don't look at that date to determine citizenship. Why? What do you think?
And that's because would that also be based off the fact that her citizenship could have been affected within that time period?
It could have been. It could have been. But also, do we always know when the date of injury occurs?
Right.
We don't.
No, sir.
Right? We don't always know. We're looking for some certainty, and maybe the most certainty comes with the date of filing. It's clear. There's no dispute about when the lawsuit was filed, and it's actually when the case came before the court, right?
Right.
So claims often arise over a period of time, not on a single date. This way is much cleaner, okay? To look to citizenship on the date of filing, right? It's also a little bit less arbitrary. All right. What does the court say about the burden of demonstrating diversity? Who has to prove the citizenship in question?
The plaintiff.
Why?
Because she is the one who brought the suit before the case, before the federal court, based on diversity jurisdiction.
and it's her citizenship that's being questioned, right?
Right.
Now, this is a little bit different, friends, than what we're going to see in motion practice. Usually, who filed the motion here, Mr. Henderson? Did the plaintiff or the doctors?
The motion was filed by the defendant, the doctors.
Right, the doctors, right? Usually, the party that brings the motion has the burden of proof associated with that motion. But here, the court clarifies when you're talking about citizenship, the party whose citizenship is in question bears the burden of demonstrating the citizenship. That will keep the case in federal court. Remember, federal courts have limited, right, by design, limited jurisdiction. So diversity is no joke. Federal jurisdiction is no joke. It's limited. She didn't file the motion, Ms. Gordon, but she has the burden to demonstrate by convincing evidence that diversity of citizenship jurisdiction exists. Okay, so the party who is asserting diversity. What about citizenship? What does the court say? How do we define citizenship for purposes of diversity jurisdiction? What is the word the court looks at?
Domicile.
Domicile. A person's citizenship is defined by his or her domicile. Did you look that word up, Mr. Henderson, by chance?
I had a good idea of what it meant before.
Okay, what do you think it means?
It means the set home where somebody lives, somebody's
Okay.
set residence.
Okay, that makes sense. But the court was clear to say it's not about residence, right? Now you're saying set. Black's Law Dictionary says a person's legal home. Domicile means a person's legal home. The place where a man or woman, that's my editorializing, has his true, fixed, and permanent home and principal establishment, and to which, whenever he or she is absent, he or she has the intent of returning. Generally, physical presence within a state and the intention to make it one's home are the requisites of establishing a domicile. What did the court, in ascertaining the test for determining, what did the court do to ascertain the test for determining a person's domicile? It looked at other legal authorities. Did you pick that up?
Yes, sir.
What did it look to?
It
What kinds of cases?
It looked to a case by the Third Circuit.
Okay.
And also a case by the, was it both?
By the Supreme Court, right? That 1886 case?
The 1886 case.
Yeah, you're looking at that. Look on page 46, right? The court looks at what appellate courts have said about domicile, right?
Right.
And it looks specifically to what the Supreme Court has said and Third Circuit courts. Why do you think it looked at the Third Circuit courts, Mr. Henderson?
It was because they're also federal district courts.
They're federal appellate courts, right? So the Court of Appeals, the U.S. District Court, the U.S. Court of Appeals for the Third Circuit. Geographically, what area do you think that encompasses?
Oh, that would be in a similar, that would be in the state where the court.
Okay. Right? The U.S. District Court for the Western District of Pennsylvania falls within the Third Circuit Court of Appeals. Okay? And when an appeal is taken up from the Third Circuit, it's taken up to the U.S. Supreme Court. Okay? So this trial court is looking at what other courts above it from a hierarchical standpoint, a precedential standpoint have said. Okay? And you see different things they take from each case, okay? From the Chicago and Northwestern Railroad case, the court says that domicile is determined by the trier of fact. It's a factual question, right? In the Gordon case, the court is the trier of fact, okay? There's no jury yet. You're deciding this early on motions. Okay, from the Krasnoff case, 1966, the fact of residency must be coupled with a finding of intent to remain indefinite. Proof of intent to remain permanently is not the test. If the new state is to be one's home for an indefinite period of time, he has acquired a new domicile. Okay? And it looks to subjective manifestation, meaning what did the person whose citizenship is in question What did she think and do? Then the Gallagher case says the emphasis of the court on the permanence of the anticipated attachment to a case, in our opinion, required too much of the plaintiff. It is enough to intend to make the new state one's home. It is not important if there is within contemplation a vague possibility of eventually going elsewhere or even returning whence one came. If the new state is to be one's home for an indefinite period of time, he has acquired a new domicile. Finally, it is the intention at the time of arrival. That is important, okay? The fact that the plaintiff may later have acquired doubts about remaining in her new home or may have been called upon to leave it is not relevant so long as the subsequent doubt or the circumstance of leaving does not indicate that the intention to make the place the plaintiff's home never existed. So the court looks at these cases, takes sort of precedential value from each and says, what about intent, Mr. Henderson? What does in terms of citizenship and determining it in a diversity of citizenship dispute, what does the person, what kind of intent needs to be manifested? You know?
Well, they have to have the intent to, they have to intend to remain in the state they're claiming citizenship in indefinitely.
Okay. Good. Okay. A person's intent, right, to make a new state one's home, even if only for an indefinite period of time, not forever, right, is a significant factor in this subjective determination. Not objective, what you and I think, but subjective, what Miss Gordon was thinking, what she intended. Domicile equals, according to the court, residence with the intent to remain indefinitely. Residence with the intent to remain indefinitely. Note that the court uses pretty interesting terminology. I love this. Acquisition of domicile. The idea of losing and gaining domicile. And courts have held that a person doesn't lose her old domicile until she acquires a new one. That's important, until she acquires a new one. That is until she goes to another state with the intent to reside indefinitely in that new state, okay? So having articulated, right? And just as far as evidence, how many of you moved to Memphis to attend law school? I can't even see, raise your hands, but the ones I can see, right? Some of you did. Some of you probably rented a new apartment, maybe joined a gym, or you will, opened a local bank account, right? Getting a local driver's license. Whether or not you intend to remain in Memphis may be a question. Having articulated this test, Mr. Henderson, you are doing great, for determining the plaintiff's domicile, the court goes about, quote, reckoning up the indicators, pointing for and against acquisition of a new domicile, right? They list sort of what speaks to, this is on page 45, right? The fact supporting her position, the defendant's position that Susan Gordon is still a citizen of Pennsylvania and hasn't acquired a new residence or citizenship in Idaho. And the court also reviews facts that support the plaintiff's position, Susan Gordon's position, that she has acquired citizenship in Idaho. What do they hold? What does the court hold?
The court holds that Ms. Gordon's facts that proved her citizenship were valid,
okay,
and that the defendant's motion was denied and diversity jurisdiction was granted.
Okay. The court holds, right? The court concludes that upon the facts of this case, and remember that diversity is determined by the trier of fact. Okay, in this case, the court, considering the student's connection with Idaho and her subjective intention of not returning to Pennsylvania in the foreseeable future, that she is a citizen of Ohio for the purpose of diversity jurisdiction, and the motion to dismiss must be denied. Okay? So do the defendants win or lose their motion, Mr. Henderson?
They lost their motion.
They lost, which means what? Was there or was there not diversity of citizenship?
That means there was diversity of citizenship.
And so could the federal court keep this case or not?
They could.
Okay. I want everybody to understand that. This doesn't mean that Miss Gordon wins. She doesn't win on the merits yet. Okay. And the case, the opinion we read, doesn't concern itself with any of that. right? She wins in the sense that her case in federal court that she filed, not in state court, she chose to file in federal court, can remain in federal court. If she had lost, the case would go away from federal court. Could she refile in state court? It depends. It might depend on other things, how much time had passed since the alleged injury, what the statute of limitations might be, right? The time before which she would be barred from bringing a lawsuit claiming that specific injury, and some other factors, right? She might be able to refile in state court and not lose anything but the time and money she spent, right, on lawyers to litigate the federal court case to this point. But she could go forward because the court at the end of the day said, we have the ability to hear this case pursuant to diversity of citizenship jurisdiction, a form of subject matter jurisdiction, right? We can hear this case. Note, it has nothing to do with the type of case in terms of the substance, right? Medical malpractice. That's a state law claim. And the court, as we're going to talk about when we study Erie in the spring, the Erie doctrine, right? Court still would have to decide if it gets to that point, what law are they going to apply? Which state's law? Okay. But they're not going to apply federal law to the case. But diversity of citizenship, because the dispute involves citizens of two different states, lets the court keep the case. That's what subject matter jurisdiction is. At the end of the day, and it's a big factor, there are other things the court needs. We'll learn about personal jurisdiction and venue. We'll learn about other issues, other boxes that need to be checked in order for a court to keep a case. But this checks off the all-important subject matter jurisdiction box, okay? Where there's not a federal question presented, you need to have diversity of citizenship or some other basis, right, for the court to keep the case. Austin Horde, what is your question?
Hi, so we might be getting to this a little bit later, but what might be Gordon's incentive to insist that the federal court hears this case?
Okay, anybody want to weigh in on that? Good question. What do you think, Mr. Horde?
Maybe she thinks that the chances of her winning the case are better if there's no bias involved, or
who would the bias be involved? If the case goes forward in state court, because remember, there is a likelihood of concurrent jurisdiction here, meaning state courts could almost certainly hear this case, and she could have filed, right? She filed in, not in Idaho, she filed in a federal court in Pennsylvania, right? What bias might she be concerned about if she goes ahead in federal court? It's a great question, Mr. Horde.
she might feel like she's an underdog in a way, going
Why?
against like doctors that could have greater influence in Erie.
Yeah, the doctors who, by the way, are still in Erie. Where is Miss Gordon?
Idaho.
Yes, and has avowed that she doesn't want to be back in Pennsylvania, right? Plus, you have doctors who are professionally probably more well-established, almost certainly, in a smaller town. We're not talking about Nashville or Memphis or Pittsburgh or Philadelphia. I'm from Philadelphia, by the way. Couldn't be further away from Erie, like 6 or 7 hours away, maybe even more, right? But a smaller town where the doctors are probably known entities, and she's not. It may be that the jury pool is bigger, and she might get folks from outside of just Erie. Whereas if she filed in state court in Erie, she might just have jurors from Erie. So there are some very practical considerations at play, most of them tied, likely, to a fear of bias if she goes forward in state court. Great question. Okay.
And
sorry,
Ms. also.
Crosby.
Hi, so
Yeah.
I was just wondering, since burden of proof falls upon the person that has to be proving their citizenship is in question, how do courts prevent this from like someone just doing this to delay the process? Like if someone just were to just call upon someone's citizenship to prolong the result.
Oh. You don't know what's going on in that dispute. That also is a good question, and that is a tactic. You know, if you are concerned about being victorious on the merits, you're going to challenge the procedure, right? So, yeah, oh, absolutely. I mean, it is a defense that can be raised earlier, and you are going to raise any kind of defense in certain situations. If the doctors wanted to go forward in federal court, they might not challenge it. And there might be a reason that they're more comfortable there too, right? So it is, to your question, a tactical call. And, you know, in every given situation, there are maybe reasons to challenge on procedural issues, and there may be reasons to hold off. But like any, you know, X versus Y, right? If X initiated the dispute, Y is going to use every tactic in the book, right, to make the dispute go away. Does that make sense?
Mm-hmm. Thank
okay. You. Good questions. Mr. Hort, I didn't mean to cut you off, but I want to conclude. We're running out of time. I just want to say this. We are going to pick up with Moss versus Perry, right? So for next week, have that reading. I posted additional reading, okay, to eCourseware and to Twin. Make sure you look there. It's up now, the reading for next week. And for now, I'm going to post week by week, okay? So you're ahead of the game in terms of Moss versus Perry, but there are additional assignments that I want you to make sure you get through for both Monday and Wednesday. We're going to have a great semester and a great year. I'm looking forward to being with all of you. Okay. I also posted, it's early, but for next week, office hours on Twin, you need to sign up. We'll go over a lot of this stuff on Monday's class. Have a wonderful